rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good afternoon. We're here for oral argument in case number CV170513, Elizabeth Monje versus John J. Corey. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of the time for rebuttal if desired. Also, we have read the briefs and have discussed the case in conference. Counsel, you may proceed.
Good afternoon, Your Honor. Christopher Engel for appellants Elizabeth Monje and Mark Monje, as well as their 3 minor children.
And counsel, if you can come up to the podium, please.
Yes, Your Honor.
Thank you.
May it please the Court, I know that we only have a limited amount of time here, and so before I launch into my description of all the facts and issues that I think are important, I wanted to ask, is there any specific issue that the Court would like me to address, any specific questions? Because I'd like to get those out of the way while I have the most time.
Why don't we start with your presentation and then we'll interject.
Okay. The brief facts are that Elizabeth Monje is a mother of several children, one of whom has special needs. She was enrolled in school to be a dental hygienist. She had no injuries. She went in for surgery, and she was injured during that surgery. Both parties agree that the injury definitely occurred during the surgery. It is only the mechanism of injury that is in dispute. She now has permanent injuries and disabilities. It's difficult for her to care for the children, especially the special needs one. And she can no longer be a dental hygienist. She's currently unemployed. Now, with respect to the legal issues, my argument is pretty clear, I think. The the standard for summary judgment is that they need to show some evidence from which a jury could conclude that Dr. Corey was negligent. For expert witnesses in medical malpractice actions, I need to show that it was more likely than not, to a reasonable degree of medical probability, that Dr. Corey caused the injury. We have that. Dr. Common's preliminary expert affidavit, which is index of record 53, states, in my expert opinion, Dr. Corey probably, or more likely than not, was negligent in performing the augmentation procedure, and this negligence probably, or more likely than not, caused the injury to Ms. Monje's brachial plexus nerves. It also makes logical sense. She didn't have any injuries. She laid down on the operating table. She woke up, and she had injuries right then and there. She was unconscious that entire time, but it seems obvious that anyone would conclude that the injury occurred during that surgery. Ms. Monje believes that. Dr. Commons believes that. She should get her day in court. Now, what I want to do is concentrate on the defense arguments because, that's why we're here. The first argument that they raised was that the supplement, we filed a preliminary expert opinion of Dr. Commons, and then defendants moved for summary judgment. We opposed, and we cited both the preliminary affidavit and his deposition testimony. In fact, we submitted the entire deposition transcript. The court granted summary judgment, and we moved for reconsideration. We also submitted a supplemental affidavit because it was obvious to me that the trial court was misinterpreting what Dr. Commons had said during his deposition. What he said is that there are 2 mechanisms where Ms. Monje could have been injured without negligence. One is an autoimmune reaction. It's possible that somebody is allergic to specific materials or tools, but the problem is that autoimmune reactions take time to develop. They don't occur immediately. And had that been the case, it would not have occurred on only the right side of Ms. Monje's body. It would have occurred on both sides. The second is a cervical rib. It's an extra rib above the rib cage. And it's possible that if somebody has a cervical rib, that...
Counsel,
yes.
The second affidavit from Dr. Commons, that was Wasn't that produced to the Superior Court 7 weeks after the Superior Court granted summary judgment?
Yes, I believe that's approximately right. What happened is the Superior Court granted summary judgment. We sent the ruling to Dr. Commons and showed him how his testimony was being misconstrued. And then we had to get a supplemental affidavit from Dr. Commons and then file it with the Superior Court. That did take time.
Go ahead.
The point I want to make here is that the supplemental affidavit shouldn't have been necessary. The court should not have granted summary judgment in the first place. But after it did, we filed the supplemental affidavit to show, hey, this is a mistake. These are the mechanisms that could cause the injury without negligence, but they're not present here. It's not an autoimmune reaction because you wouldn't have that immediately upon waking up. There's no evidence that she has a cervical rib. Certainly, defense is welcome to present those arguments at trial and argue that one of those things happened, but she still gets her day in court. So long as it's possible that Dr. Corey caused the injury, that should have been enough. Now, the affidavit wasn't filed in support of the motion for summary judgment, and this is important. It was filed in support of the motion for reconsideration. So the arguments that are being made about Rule 7.1A4 and the reliance on Boland is misplaced. In Boland, the plaintiff argued that he didn't need expert witness testimony, and defense said, yes, you do. And they moved for summary judgment. And he opposed summary judgment and said, I still don't need expert witness testimony. And I believe after the court granted summary judgment, for the first time, he produced expert witness testimony. That's distinguishable. He didn't come up with the expert witness testimony until after the court granted summary judgment. Here, we had expert witness testimony both in the preliminary affidavit and in the deposition, both of which state that it is more probable than not that Dr. Corey was the cause of the injury. The arguments about considering the portions of the record which are brought to its attention, there is a body of case law that says the trial court shall consider the entire record. And there's another body of case law that says you can't thrust it upon the trial court judge and make them search through the entire record and say somewhere in there is a disputed fact. What counsel is required to do is say, hey, Your Honor, these are the facts that require you to deny summary judgment. You don't have to just say somewhere in the record, there's some fact you shouldn't grant summary judgment. You have to show the judge why they shouldn't grant summary judgment. And we did that. We showed the trial court the preliminary affidavit. We showed the court the deposition testimony. So we did provide the trial court with the evidence it needed to deny summary judgment.
Isn't that the trial court's call? I mean, the trial court read the transcript, and the transcript and the affidavit can be read to support your opponent's argument.
One, I don't think it is the trial court's call. I think the trial court is required to review those portions of the record brought to its attention. And I did go through Dr.
What did they ignore? That's the part I'm missing, counsel. Can you point that out to us?
Yes. We submitted Dr. Common's entire transcript, and we cited several portions. One of the portions I think is most telling is on pages 67 through 70. I asked, do you have thoughts about what are the most likely mechanisms of that injury? Answer, I think that either an opening, stretching with the scissors, clamping a bleeder is a possibility, and clamping part of the brachial plexus using the Bovie electric cauterizing unit and heating the nerve using a retractor. Skipping down to page 70, I think it's probably a retraction injury where there was a retraction that was a little bit rigorous and stretched the plexus. Dr. Commons believes that Dr. Corey caused this injury. Those parts were shown to the trial court judge, along with the portion of the affidavit that I cited earlier. He believes, to a reasonable degree of medical certainty, Dr. Corey caused the injury, and it was either misusing the surgical tools or mispositioning the arm.
What about your Dr. Commons statement when defense counsel asked the following question? Would it be fair to assume that in review of the operative report, it appears that Dr. Corey's surgical technique was appropriate and within the standard of care of transaxillary augmentation mammoplasty? and then Dr. Commons responded by saying, yes, it does. So that's giving me some pause, counsel, that your client's expert couldn't even, or agreed that Dr. Corey acted within the standard of care, that there was no breach of standard of care.
It's a different issue, Your Honor. My understanding is
Is that an issue that the trial court needs to decide in deciding summary judgment?
it was not the issue before the court on summary judgment. The issue before the court was whether Dr. Commons more likely than not caused the injury. I know the portion that you're talking about, and my understanding is that there's three basic mechanisms to do breast augmentations. One is to cut around the nipple, the other one is to cut underneath the breast, and the third one is to go in through the armpit. Going in through the armpit is one of the it's one of the accepted procedures. It's not perhaps the one used by most doctors, but using that procedure is within the standard of care. So going in through the sidewall, the muscle on the torso, yes, that is a proper surgical procedure. However, using that procedure was not the cause of action. It was the mistakes that were made during that procedure that formed the cause of action. Does that address your concern, Your Honor? Okay.
I guess so. Go ahead.
We do agree with defense counsel that when there is, summary judgment shouldn't be granted when there's only a scintilla of evidence. But this is more than a scintilla of evidence. She goes in for surgery. She's not injured. She wakes up. She is injured. She believes that she was injured during the surgery. A world-renowned surgeon says he's reviewed the record, and he's nearly certain that Dr. Corey either mispositioned the arm or misused the instruments. There are two mechanisms that would not involve negligence, but they're not likely here. That is more than a scintilla. It is near certainty. Defense argues that there's no expert opinion that the standard of care was breached because Dr. Commons stated that he's sure that Dr. Corey was using all due care, and a brachial plexus injury can happen even if the surgeon fully complies with the standard of care. Well, no one in this case is arguing that Dr. Corey went out to injure Ms. Monje intentionally. Even I'm sure that he intended to do the surgery properly. It's a mistake. It's an accident. Even though he intended to do the surgery properly, he made a mistake somewhere during that surgery, and Dr. Commons did testify that he probably misused the instruments or mispositioned the arm, and that is a breach of the standard of care. The other argument the defendants have raised is that it's possible that it was one of the techs. It was one of the people standing around the surgery table, such as the anesthesiologist or one of the nurses. But there's two problems with that. The first is Dr. Corey is responsible for monitoring the surgical team. In the same way that I, as an attorney, am responsible for my law clerks and my paralegals and my secretary and my associates, so too is a surgeon responsible for the anesthesiologist and the nurses, making sure that they do their job properly. He's supposed to verify those things before he does his job. If he sees that the arm is out of position, he needs to put it back. He should not ignore the position of the arm and stick the surgery tools in.
But isn't it the case that Dr. Commons testified that there was no evidence that Mrs. Monje's injuries resulted from actions taken by other members of the
Correct.
surgical team?
Yes. It is possible that it was one of the other surgery team members, but there's no evidence that they actually did anything wrong. The overwhelming evidence is that it was Dr. Corey. He speculates and he argues that it could have been one of his team, but there's no evidence that any of the team members did anything wrong. And even if they did, it wouldn't get him out of liability. Two different reasons. One, he's responsible for supervising the team. Two, is that there's two causes of action. One is the medical malpractice claim against Dr. Corey, but the second is the respondeat superior claim against the surgical team. Even if it was the surgical team, the second defendant in this case is Dr. John Corey, MD, PC, the company. If it was one of the employees of the company that was negligent, then the negligence would still flow up through the company. We can still go to trial. And Dr. Corey is essentially arguing that it wasn't him misusing the tools, it was instead him failing to supervise his surgical team. And that doesn't really get him out of liability. It just changes his liability from being directly responsible to failing to ensure that other people didn't injure Miss Monje. Corey's main support for arguing that the negligence of the others in the operating room exculpates him from liability is Sanchez. However, Sanchez doesn't support that claim. It expressly recognizes two exceptions to the exclusive control requirement. Those are vicarious liability, which we have here, and shared control, which is also present here. Sanchez does not support the argument that he's making. I realize that I now have 5 minutes and 15 seconds left.
Let me ask you a quick question.
Yes.
Just before you leave the podium. So can you tell us exactly what is it that, in your position, Dr. Corey did that caused the injury?
It's one of two things. It's either misusing the tools or it's mispositioning the arm. We can't tell which. You'd have to go back in time and watch the surgery. You'd have to have cameras at various different angles. And if you had all of that stuff, you could see what it was. There's no way to go back in retrospect and tell which one it was. Dr. Commons opined that more likely than not, it was the tools, that it was tension on the muscle wall that tore the muscle and thereby caused the injury, and it's irreparable. But it's also possible that it wasn't the tool tearing, it was the arm being in the wrong position. So when the surgical tools were inserted, they were tearing through the wrong portion of the muscle wall. On the whole, it's probably misuse of the tools. But you can't say for certain. You can only say it's one of those two, and there is always the possibility that it's some unknown third factor. And that's what Dr. Corey's argument is. I mean, taking it to a ridiculous and extreme example, it could be that everybody left the room and somebody snuck in and injured Miss Monje and then left, and nobody knew. Possibility exists. If they want to make that argument, they're welcome to. But that's not the standard for summary judgment. We don't have to prove with 100% certainty that absolutely it was Dr. Corey and no one else, and that it absolutely happened in this way. What we have to prove to get to a jury is that it's possible that it was Dr. Corey. And in this case, we've shown not only that it's possible, but it's almost certainly Dr. Corey. I'm going to reserve the rest of my time for rebuttal. Thank you, Your Honors.
May it please the Court, my name is John Egbert, and I represent Dr. Corey and his professional organization. Let me dive right into what the evidence is not in this case in terms of the expert opinions. The law is very clear that in order to successfully oppose summary judgment, the plaintiffs had to show two things. They had to have expert testimony on two things. One was that Dr. Corey fell below the standard of care, and there also has to be an expert opinion that Dr. Corey's falling below the standard of care caused the injury. Those two things have to be there, and here, neither one is here, and that's exactly what the trial court found. Admittedly, those are usually issues of fact that can't be decided on summary judgment, but the case law is very clear that if there is no evidence, no expert opinion on those two essential critical factors, then summary judgment is appropriate. So let's talk about the first. Very quickly, I want to address the absence of expert opinion with respect to falling below the standard of care. But really, the easiest way to resolve this case is by looking at the causation piece, because that one is clearer and easier to show that it's just not there. But I don't want to. I want to address both of them. The first will be pretty quick. Dr. Commons opined that the injury to Ms. Monje, not sure how counsel or how it's properly pronounced, most likely resulted from either the mispositioning or the instrumentation. He was asked the following question: you agree that could be done even though Dr. Corey was using all due care in that procedure, right? Answer: sure, I am sure he was. He was what? He was using all due care. But it still can happen. So here's the expert saying, I'm sure he was using all due care. And that's not, counsel says, well, that's a matter of intent. I'm sure he was not intending to do anything wrong. That's not what is being talked about here. Intent isn't used here. It's talking about the standard of care, due care. And his own expert opined in the deposition, I'm sure he was exercising all due care. If Dr. Commons is sure of that, then there's no falling below the standard of care. That essential requirement is missing. Plaintiff's counsel, at the end of his deposition, Dr. Commons' deposition, then asked a few questions, including an attempt to rehabilitate that testimony, and it kind of backfired. Question. There were a lot of questions about, hey, we have the perfect surgeon and that person does nothing wrong, but the patient is injured nonetheless. Do you think that's the situation with Ms. Monje's injury? Answer. I do think that that's a likely situation where the operation was conducted properly. But something happened between the beginning and the end of that operation and damaged her brachial plexus. That's at pages 68 and 69. It seems what became clear after, when you read the entire deposition of Dr. Commons, is that what he really thinks is that if something bad happens while I'm the surgeon in an operating room, even if it's not because I did anything wrong myself, but it just happens, then I'm the captain of the ship and I'm responsible for that. Well, that's not the law in Arizona. The law, as I said at the beginning, is there has to be a falling below the standard of care by who? By the defendant. And there has to be a causal link between that falling below the standard of care and the injury. There's no strict liability here just because it happens sometime during the operation procedure. Now, he argues that Dr. Commons said during his deposition, well, there is also, the surgeon does have the standard of care does require the surgeon to watch the other members of the team and to try to prevent them from causing the injury. Okay, so even if we accept that, then that gets us to the causation problem that I think is very clear and simple to address here. Dr. Commons never testified that Dr. Corey's failure to watch the other team members caused the injury to the plaintiff. To the contrary, he admitted that he did not know whether Dr. Corey could have done anything to prevent another team member from causing the injury. And I would call the court's attention, and I think this is the piece that's most critical, pages 59 and 60 of the deposition. Question. So I take it that based on what you told me, you cannot state to a reasonable degree of medical probability that Dr. Corey himself did anything negligent or below the standard of care to cause Ms. Monje's brachial plexus injury. True? Answer. Something happened between when the lady entered surgery and the time of ending that resulted in an injury to her brachial structure, brachioplasty, brachial plexus injury. I think the things we've mentioned, one of them or multiple, hold true. And here's the critical part. Is there something he could have done to prevent that? I don't know. But he was in charge and something happened and the results were rather tragic. An expert doctor saying, I don't know if he could have prevented it, whether there's anything he could have done to prevent that, is not establishing the causal link that's required between some falling below the standard of care and the injury. That's an admission that there is no testimony of the causal link. So just to be sure, then immediately after that series of questions I just read, counsel goes back and says, let's make sure we understand here, doctor. So what you're saying, Dr. Commons, is that you can't say whether there's anything he could have done to prevent this within reason. And Dr. Commons then responded that that was true. That ends the analysis, I believe, with respect to whether summary judgment was appropriate. let me take a step back and make a reference to the preliminary affidavit, which counsel read from, which has the very conclusory language. I opine, based on medical probability that he fell below the standard of care and he caused the injury. There's a long body of case law that says that conclusory ultimate facts are not enough to withstand or support a motion for summary judgment. Here we have that was given at the very beginning at the preliminary, the statute requires in a medical malpractice action that you give a preliminary affidavit. That was given, that conclusory language was used, and then we take his deposition, and that's when he says, well, no, I don't know whether there's anything he could have done to prevent that injury. That's not good enough. You can't just use the boilerplate language in your preliminary affidavit, and then when you get down to explaining, well, what do you really mean by that, and saying, I have no idea whether there was causation, that doesn't prevent summary judgment. And so the reliance on that is completely misplaced. Then the only other issue I think that's in this case is whether or not the court should have, after they responded to the motion for summary judgment, after the court granted summary judgment, whether the court should have then also considered the additional affidavit that was submitted in conjunction with the motion that they filed, which is index of record number 87. There's a couple things that are important about that. Counsel says that if the opinions that were actually given by Dr. Commons are sufficient, and he shouldn't have had to even submit the affidavit, and that's why he didn't have that affidavit until afterwards. Well, if they're sufficient, they stand on their own, and we can just look at them and decide whether or not they were sufficient to withstand summary judgment. We've already talked about that. They weren't. There was no causation testimony by Dr. Commons. And so if he says they were sufficient, we don't need to consider that. We'll take him at his word, and we don't need to look at it. But the affidavit, if you look at it carefully, actually doesn't even talk about Dr. Corey. It talks about a Dr. Green whose conduct fell below the standard of care. There's no mention whatsoever about Dr. Corey. Now, whether that was a typographical error or some sort of transcript, I don't know, but that's what's in the record. And there is there's nothing in that affidavit that is supportive of his position. And then,
Counsel, Mr. Engel says that this was properly filed as a motion to reconsider rather than a motion to.
Yeah, that's exactly where I'm going to go next, because they called the motion, Your Honor. I'm going to quote the name of the motion that they filed, which is, again, index of record 87. Plaintiff's motion to supplement their response to defendant's second motion for summary judgment. That's what they called it then. And in their opening brief, he also says the trial court erred by refusing to consider an affidavit brought to its attention by the parties in the context of a motion for summary judgment. That's the argument that I responded to in my answering brief, and it was only when he got to the reply that he then has this recharacterization, which even is contradictory of the name that they gave the motion to begin with. So it's not, the bottom line is that it was up to the trial court's discretion whether, after the trial court had already ruled on the motion for summary judgment, whether it was now going to allow this late filed supplemental affidavit to come in. And it clearly was not an abuse of discretion. That's within the trial court's discretion to decide. And so we think that issue should be summarily rejected in terms of that there was no error by the trial court in disregarding that. But as I say, even if we were to consider it, it does nothing in terms of solving the absence of causation expert testimony that we point out from Dr. Commons. So we would, based on that, what I consider to be overwhelming lack of evidence of causation expert testimony in Dr. Commons' deposition, we would ask the court to uphold this grant of summary judgment by the trial court. And unless there's any questions, I'll give up my last 7.5 minutes.
Thank you.
Thank you.
The opposition says that we must show two things, one of which was that Corey breached the standard of care. That's not correct. What we need to show it is more likely than not, to a reasonable degree of medical probability, that he breached the standard of care. It's not an absolute proof. It's not. In civil law, it's preponderance of the evidence.
Well, even under that standard, counsel, your expert, your client's expert, said that Dr. Corey operated under this within the standard of care.
Well, he used one of the correct methods to perform the surgery, but something happened during that surgery, and it was either mispositioning the tools, or I'm sorry, mispositioning the arm or misusing the tools, is what he said. I'm sure that
Wouldn't that fall then under some standard of care, fall below a standard of care?
Yeah, misusing the tools.
Then why didn't Dr. Cummins say that?
He does.
He says it must have happened one of those two ways, but he didn't say that that was below the standard of care. At least not into the question and answer that I asked you before when you were up here previously.
The standard of care, and let's go back to the preliminary affidavit.
No, let's talk about his deposition.
Okay. In his deposition, he was asked what are the most likely mechanisms of injury. And he said it was either in the opening or the stretching with the scissors or the clamping the bleeder. In the end, he says it's probably a retraction injury.
Okay, if we could just, I keep getting hung up on, you have surgery. There are inherent risks whenever you have surgery. There's a standard of care. I don't see anywhere in that deposition that sets forth that those injuries necessarily are a breach of the standard of care. That's what I'm having trouble finding, counsel.
Okay. Well, I look for the exact testimony, and what I can do is give you some of the parts that address that. But one thing I want to make clear is that Dr. Commons isn't going to repeat his earlier statements in answering every single question. He's not going to begin every single answer with, as I previously stated, I think Dr. Corey breached the standard of care either by this or by that. He's going to assume at some point that people know what he said before.
Well, but he was asked specifically, is there something he could have done to prevent that, meaning the injury? And his answer was he didn't know.
And that's true. If somebody, you can't test a patient for every single possible reaction. You can't test them, are they allergic to the steel? Are they allergic to the anesthesia? Are they allergic to this or that? At some point, you go ahead and do the surgery.
So if you don't know what a physician could have done to protect the patient, to prevent injury, then how can you say that whatever injury that occurred was due to his falling below the standard of care?
Well, actually, let me add one more sentence to
Very
this.
quickly, because you're out of time.
I'm sorry. Okay. The cervical rib. You could x-ray every single patient to see if they have an extra rib, but it's a very abnormal finding. And he reviewed all of her records. It's not in there. It would be there if she had an extra rib. So it's possible that he did use all due care, and the injury could have occurred nonetheless. It's just not likely.
All right.
I had additional arguments, but I'm out of
Are they
time.
in your briefing?
They were responsive to opposing counsel's arguments here. I could try to run through them in a minute or less, or I can wrap up right now.
You can wrap up.
I would ask the court to reverse the trial court's judgment and remand for further proceedings. Thank you, Your Honor.
Thank you, counsel.
Counsel.
Counsel, we thank you both for your arguments. This matter is now taken under advisement, and we are going to briefly take a recess to prepare for the next argument. Thank you.